Larry's done almost all of the groundwork for my discussion, so it can be very quick. He told you about the history of the phrase natural-born citizen. He told you about the statutes in 1790 and 1795. He told you about a stray quote from James Madison. It's always nice. But I'm going to approach the question slightly differently. So is the term natural-born citizen just like equal protection of the laws, or is it a term of art like, say, a Bill of Attainder? Well, everything that I've been able to figure out suggests to me that it's a legal term of art. And therefore, we have a slightly different analysis. We ask, what would a lawyer think it meant in 1788 instead of what would an ordinary citizen think it meant? So for terms of art, we ask what a professionally well-trained lawyer would think. A professional well-trained lawyer would reason as follows. They would say, well, we are a republic, we're not a monarchy. They did have this thing in England that was called a natural-born subject. So this is probably like a riff off of the English concept of natural-born subject, and we know a couple of things about natural-born subjects. One, it's based on the idea that there is a reciprocal relation between the sovereign and the citizen. The sovereign owes allegiance, and the citizen owes allegiance, and the sovereign offers protection of law, right, to the citizen. Right, that idea. And so the real question is, how far does the sovereign's protection extend? And the common law, old common law rule was it was largely confined to the place where you were born. If you were born within the sovereign's territories, then you had that reciprocal allegiance. But it also turns out there were exceptions made for diplomats, as Larry said, and for people fighting the King's Wars. And it also turns out that Parliament, starting in the 1600s and through the 1700s, repeatedly changed the legal definition of natural-born subject. First because of the English Civil War, and later to deal with problems of empire. So we know that if you were a well-trained lawyer in 1788, you would have known all this, and you would have realized that it's a common law idea that can be changed by Parliament through statute, and that it was changed through statute repeatedly, and that the question then would come, we move from a monarchy to a republic. And the question is, as we move from a monarchy to a republic, there are a couple of things that change. First of all, one is the power, where power is lodged. And the second question is whether or not there's a constitutional idea as opposed to merely common law idea. So let's take the first one first. So in Britain, basically the sovereign is the king and parliament. So the king and parliament pretty much can do anything it wants. They have parliamentary sovereignty. But in the United States, we have popular sovereignty. So we delegate powers to the states and to the federal government, and we delegate powers within the federal government to the various branches. So we cannot simply transfer what they had in Britain over. We have to ask, how does it fit into our scheme? And so the question we have to ask is, who had the power to define citizenship in the new federal scheme? And the answer is Congress does. Congress has a power of naturalization, a uniform rule of naturalization. Parliament had two kinds of naturalization. They could make someone a citizen who had been born in another country and was not a subject of the king, and they could also declare who was a natural-born subject. They had two naturalization powers. So the question is, when we look at the American Constitution, which includes all of the powers together, when you take the three branches and the states together, all of the powers, they're vested somewhere. Where are these two naturalization powers vested? The answer is they're vested in the American Congress. And that's actually a good idea. It makes sense why. Congress is the democratic branch. Congress is the representative branch. We live in a republic. To decide basic questions of who's a citizen and who can be eligible to be president, we would rather place that in the democratic branch, the representative branch in Congress, so it makes sense from the standpoint of structure. Okay, next question. Is it a common law? What happens when you take a common law term and you move it into a constitution? So one possibility is it's fixed and frozen for all time, and therefore whatever it turns out the meaning was at the time is fixed forever, right? That was really Larry's originalist argument, okay? I don't think so. If you think about the structural argument I just made, right, it's an argument from structure, what's been transferred over constitutionally is a common law baseline and a power of Congress. Of Parliament, now a power of Congress. So what gets transferred over is there's a common law baseline of what a natural-born citizen is, which isn't really worked out at the time. It's really basically an assumption. It's about some relation. You have to have a connection to the republic. And the most obvious way you demonstrate the connection to the republic is being born there. And then it's also true that there are some common, even in the common law, there were various extensions. So it evolved over time. And then Parliament, now Congress, has the power to expand it, as long as Parliament or Congress is assured that there is a sufficient connection between the person and the state, that is, because it's in the republic in our case. So if that's the case, then the correct reading of the clause today is there's a common law baseline, which has now been changed, by the way, by the 14th Amendment, been constitutionalized by the 14th Amendment, birthright citizenship. And then Congress has the power to expand, in the same way Parliament had the power to expand as it did in the 1600s and 1700s. And there may be a limit, by the way, to how far Congress can expand natural-born citizen. I'll talk about that in a second, but I just want you to understand that the way to understand the clause is structurally. It's not like equal protection of the laws, which is a rights provision. It's a structural provision, and it invokes Congress's naturalization power. You read natural-born citizen against the naturalization clause in Article 1, Section 8. That's the correct way to understand it. If that's the case, then the question we have to ask is not what was the law in 1788. The question is, what's the law in 1970 when Cruz is born? And the law in 1970 was that if one of your parents was an American citizen and had established residence to a certain amount before birth, and you, in turn, established residence, then you're a citizen. And you're a citizen by birth. This is part of the citizenship statutes, which tells you who's a citizen by birth, not who can be naturalized a citizen. And that makes perfect sense structurally. Congress has two naturalization powers. It has a power to make somebody a citizen born somewhere else, and it has the power to decide who's a citizen by birth. Just as Parliament had those powers, Congress has those powers. Okay, so that's the basic idea, and that's why it's not really a difficult problem whether Cruz is a natural-born citizen. Congress, using its power under the naturalization clause, said he is a citizen by birth, he fits the terms, he's a citizen by birth. Now you might ask, well, what about natural-born citizen, right? I just left out the key word, natural-born citizen. But here's the point. Natural cannot mean as opposed to statutory. Can't. The reason why is because Parliament made statutes that changed the meaning of natural-born citizen. And any English lawyer at the time would tell you you were a natural-born subject, even though it was a result of a statute. So the distinction is not between statute and common law. Doesn't make any sense. Anybody who understood the history would realize it made no sense. What does natural mean? Well, it's part of a clause, it's part of a word, it's part of a phrase. It must mean something that's either a play on natus, born, birth, right? And nature, that is automatic. So a natural-born citizen is someone who becomes automatically a citizen at the moment of birth. They don't have to do anything else. They don't have to fill out a form. They don't have to do a fancy dance. As soon as they're born, by operation of nature, they are automatically a citizen. So this is the pun on natus, birth, and natural, automatic. And it's tied, interestingly enough, to the other part of the text, the power of naturalization, to make someone a citizen of the United States. Okay, that's fine. There are a few more bells and whistles I want to talk about. But now I want to come back to the place I started. Larry said, I'm a special kind of originalist. I'm a living originalist. I have a very thin conception of original public meaning. But here's the kicker. Here's the thing I want you to understand. Even if you don't have as thin a conception of original public meaning as I do, even if you have a thick conception, like my good friends do, or even if you had as thick a conception as Justice Thomas did, you could look at the structural argument I just made and nod your head as to every step. There's nothing in even a thick account of original public meaning that prevents you from making this structural argument and recognizing that the power of naturalization resides in a republic in the United States Congress. And therefore, even though I am a very special kind of originalist, the right one, it's also true that all my other friends who are originalists could listen to my argument and say, you know that Balkin, he's making sense. I disagree with him on gay marriage and everything else, but on this we agree because he knows how to make a structural argument. That's the big idea.